Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Megan Hennings presenting for us. If you are unfamiliar with the format of this event, first, Megan is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or in the comments section on Facebook. We'll review all questions put in the chat boxes during that Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Be sure not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Megan to get us started.
Hi, everyone. Thanks so much for joining us this afternoon for this listen and learn on tenants' rights. I'm going to go over the basics of landlord-tenant law and talk about some of the common issues that we see and folks come to us with. So with that, legal aid, as you may know, covers a wide range of topics, so civil legal matters, and we're here to serve low-income people in order to ensure access to justice and remove legal barriers to economic opportunity. We do that service in a range of different ways, and so that's sometimes advice or representation on cases, but also to provide information and self-help resources for cases that we're not able to take on with an attorney. So this is just one example of that. There's a lot more information on our website related to tenant law, but also other areas of law. And we have these other listen and learn sessions that go along with those, such as in child custody or SNAP benefits. So what we'll go over today is who is a tenant first, talking about that landlord-tenant relationship, the eviction process as it goes along in court, repairs and rent abatement, because that's a very common issue that tenants face and how to navigate it, as well as security deposits. So to start off, who is a tenant? And then we start off here because it's important to understand whether you are in a landlord-tenant relationship or not. Sometimes that's pretty obvious, right? You've signed a residential lease with the owner of a property. You are the tenant. But there is no requirement that that lease be in writing. It can be an oral lease here in North Carolina, but there does have to be some kind of exchange for someone to be the tenant, right? So that's normally an exchange of in rent, whether that's written down in the lease or you're verbally agreeing with someone, I'm going to pay $750 a month to rent this unit. But it could be other kinds of exchange, paying for certain expenses related to the apartment or some other kind of exchange of money. And in some circumstances, living in a hotel could be considered a tenancy. There's a couple different factors that go into that, including the length in which someone's staying in a hotel. But just to note that. And it's important to note also what is not a landlord-tenant relationship. And so, say if you are just a guest in someone's home, it could be for a prolonged period of time, but you're not paying rent or there's no kind of agreement as to the amount of time. There's nothing being exchanged for your stay. You are just a guest in that person's home. And that would not be subject to the process that we're going to talk about today as far as eviction and the rights that come along with having a tenancy versus just being a guest. So, the eviction process. So often before the landlord files the eviction, the landlord will give a notice to vacate or some kind of notice saying the tenancy is over or that they want you to leave. And this is sometimes required, but not always required. And part of what I want to emphasize here is there's a couple different sort of areas of law and documents that are binding in these relationships. So first of all, there is that written list or the terms of an oral lease. That is part of what, and a very important part of what is governs this relationship that you have with the landlord, and some of the specific terms, especially under it, are it's a contract. It's legally binding between the parties, and so that is one place we look to, as far as what the rules are, kind of what's the rights, what's the remedies, within this landlord-tenant relationship. But additionally, there is state law that governs. Landlord-tenant relationships as well. And so I'll talk about some of the areas in which we have state law that sets certain minimums or things that a landlord or a tenant has to do, when renting. And then additionally, if you are in a subsidized property or have a subsidized housing voucher, there could be additional federal regulations that apply to your situation and to your relationship with the landlord, and then usually a relationship with the housing authority, local housing involved authority involved there as well. So just a couple things to keep in mind as we go through the process and what governs this process. Um, and so the one of the things to think about with the notice to vacate, or this initial communication that you get from your landlord saying that they want you to leave, that they want to end the tenancy, is thinking about what you want to do in that moment before the next thing being the eviction is filed and the court process itself kicks off. So you can weigh whether, depending on what the landlord is telling you, that they would want to end the tenancy over, if that's something that you're willing to fight in court, or if moving before any of the legal process proceeds would be better for your situation. But a very important point is that the landlord must go through the court process to remove you or your belongings from the tenancy. And so a landlord cannot just change the locks without any kind of court process, or in some other way block you from being able to access the unit. That would be what we call a self-help or constructive eviction. And that is against the law, and there's remedies for that. So a landlord must use the process of eviction through the courts, to remove you from the home when there is that landlord-tenant relationship present. So summary judgment, that's essentially the kind of the legal term for eviction. And what you'll see it referred to on court documents or court proceedings. And so it just applies only to the tenants, for the landlord to regain possession and or money owed from a tenancy. So as the court process begins, the landlord files and the tenant receives a summons and a complaint. So the complaint is the detail with the basis of the eviction, and we'll go over that in a second. And you'll see on that form it says complaint and summary ejectment. And the summons is the details of the date and the time that the court hearing is going to happen. Most of the time, almost all the time, these hearings or this process starts in small claims court, and then can be appealed to district court. So that date and time of the court hearing is usually taking place in small claims court. And then the tenant may receive the notice by being handed copies of the complaint and summons by the sheriff, but it can also do it through posting, and sometimes receive it through mail as well. But the key part being that you receive the complaint and summons in some way before the proceeding happens. And again, it usually start in small claims court, and that is because the request for possession by the landlord, or for money owed less than $10,000 start in small claims. If for some reason they're requesting more than $10,000, it could be filed in district court, but usually not the case. Okay, so this that you see on the right of your screen here is that complaint and summary ejectment that I mentioned. It's a form that the administrative office of the courts has created for landlords to fill out to claim repossession or money owed around a tenancy. So it looks the same for everyone. And the box that's circled, that main section of the form there, box number 3, are the 4 bases for an eviction. So that's non-payment of rent, holdover, breach of lease, and criminal activity. And I'll go through these one by one, so we'll talk through them. Um, and sometimes the landlord may check one, they may check multiple, but that's kind of like if you're wondering why is this happening, that is the first place to look on the complaint. And so the landlord has the burden of proving the case for the eviction. You'll see on the left-hand side there's a space for the plaintiff, there's a space for the defendant. So the landlord is typically, if they're asking for the eviction, they are the plaintiff, and then the tenant is the defendant. Um, Note that you may see, you may interact with like a property manager or someone at the front desk, of the leasing office as part of your tenancy, but there's someone else that actually owns the building, maybe a company or corporation or LLC. And so you might not see the owner or the plaintiff might not be exactly who you talk to, but they might be the one, say, filing it on behalf of the owner of the building, or listed as their agent down below. And then at times too, your landlord already has an attorney, and so you'll see that they're listed as the plaintiff's attorney down there at the bottom. You can also note that above that third box, it does list the rate of rent, when the rent was due, the date the lease ended, whether it's public or subsidized housing. So check those as well. And especially note if you are in a subsidized housing unit that the rate of rent should be the tenant's share, not the rate of rent for the market rate of rent for the unit overall. So for example, if you have a housing choice voucher, it'd be the portion that you have to pay each month as the tenant, not the portion that, say, the housing authority pays, or both of those portions together. Okay, so since there are 4 boxes within that section 3, the reasons for eviction, I'm going to refer to them as box 1, box 2, box 3, and box 4, those 4 things that were listed on the last slide. So box 1 is non-payment of rent. So a tenant's rent is late and the landlord has made a clear demand for the late rent, and the landlord has waited at least 10 days for the pay of the amount that's owed before filing the eviction. And so this box can only be used for oral leases or leases without a default clause, or sometimes referred to as a forfeiture clause. And essentially that means that in a lot of the written leases, part of there is a clause included that if you are late on rent or don't pay your rent, that is a default breach of the lease, or that you can forfeit possession by not paying. But not all leases have those, especially if you have a much more, narrow, not very many terms at all lease, or the oral lease, that wouldn't include something like that. A specific thing to note with this box 1, non-payment of rent, is that a tenant can pay all the amounts due plus the court cost, before the final judgment to avoid eviction. And so that court cost is $126. That's the filing fee. And then there could be there's usually additional costs for for the sheriff to do the service and everything like that. And so it's not just the back rent that's due. There's a little bit more than that that's needed to be paid to caught up. But if a tenant finds themselves in this situation and can pay that amount, before a judgment is entered, say before you go to court, or even if you get to court and are able to pay all of that, then that can avoid the eviction and be and have the case dismissed. Okay, so the second box that is on there is holdover. And so this is that the landlord is saying that they have terminated the lease. They told the tenant that they wanted possession back by a certain date, that, the turn in the keys, tenant to be moved out, all of that by a certain date, and that the tenant has not done that. And so now they're asking the court to, give the property back to them from the tenant and to evict the tenant. Um, and this can be, it could be the best tenant in the world, and it's still that the lease term is up and the landlord has given notice and you have to move out by a certain time period. Or it could be that, something has soured within the relationship and they've asked you to move out. But for this, you would get a notice before that the lease is ending, like that notice to vacate that we had talked about before. And so the notice should end at the end of the lease period. And so, usually the end of the month, because if your lease starts on the month or ends on the last day of the month. But sometimes, leases are from like the 15th to the 15th of the next month. So just check on that. And if the lease states a specific way that the notice must be given, then the notice must follow that. And so, and let me go to the next one. I think it'll make sense. So the bare minimum for the notice requirement under North Carolina law is that it depends on what kind of lease it is. And so a year-to-year lease, the landlord has to give 30 days notice before the end of the lease period to end that tenancy. Versus a month-to-month lease, that's a 7 days notice requirement, and a week-to-week lease is 2 days notice. And note that this does work the opposite way as well, right? If you wanted to end your tenancy with this landlord, the same notice usually applies. But for the landlord's part, they have to give you this notice in relation to what kind of lease that you have. But that is just the minimum, and that's why it's important to look at what the lease says specifically around the notice, because there could be additional requirements there that the landlord needs to follow, such as the ways in which the landlord might have to give you the notice. For example, they might have to do it in writing versus just orally telling you that you need to move out. Or it might be that you have a month-to-month lease, which under the minimum is 7 days notice, but this lease that you have says actually the landlord's got to give 30 days, and so that would supersede just the minimum that's required by state law. So that's why it's important to know what the law is, but then also look specifically to what your lease states, because there could be additional protections there. Um, but if a landlord, say, gives you this date to be out by, say, the end of February, but then they accept March rent, that essentially creates a new lease term with the tenant, and that could be a defense if they then filed for eviction and enlisted holdover as the reason for it. It's also important to read your lease for sometimes there's automatic renewal clauses to the leases. And so say you had a year lease and sometimes there's terms that, if no one says anything by the end of that lease term, it automatically enters into another year-long lease. Sometimes it says that after a year is up, then it automatically goes month to month. Or week to week. And so make sure to look at that as well, because even you had a year-long lease at first, but haven't signed anything now for a couple years, and it's just, the tenancy has continued. You might want to check if you're still on that year-to-year term, or if your original lease then transformed into a month-to-month tenancy, because that impacts, the notice requirements here. Okay, the third box, and I would say is probably one of the most common, is the breach of a lease. So this is the landlord claiming that the tenant has violated a condition of the lease. And the lease must have that forfeiture clause for the landlord to be able to claim this. Most written leases have these, especially kind of the longer form like leases, usually from like the apartment association or more corporate type leases that are pretty extensive, usually have this, but it's essentially saying that as part of the agreement, part of the contract, if you violate any conditions or terms of the lease, then the landlord has the right to reclaim possession of the property. And so even though we talked about that box one non-payment, because most leases have that clause, then a lot of these non-payment cases fall under breach of the lease because one of those terms, one of the very main terms of your lease is that the tenant pays money, right, to be able to occupy the space. To live in the apartment or the home. So just know that it could still be for non-payment, even though it's not the box one or kind of the as direct language in that complaint of, tenant owes amount, landlord asks and it hasn't been paid. Um, and so we have another clipping here down at the bottom of those four boxes I talked about, but then there's also the description of breach or criminal activity. So those boxes 3 and 4, the breach and criminal activity, the landlord, when filing, must write in there what it's for. And so sometimes they just write non-payment. But this is also where things like say they might claim that you have a pet and pets aren't allowed. That could be considered a breach of the lease. Or if a guest did something that was not allowed on the property, that could be considered a breach. And so that description would have to go in there so you know more about why is the landlord filing this, right? What are they claiming as something that you did to breach the conditions of the lease? Um, and that's also where it becomes really important to read through your lease thoroughly to know what all of those terms and conditions are. And so, what are you allowed to have, say, at the property? What are you allowed to do on the property or the community grounds? I know a lot of times there are addendums to leases that have, say, like community rules, maybe guidelines around numbers of visitors or noise, quiet hours, things like that. Always good to know, exactly what are all of the conditions for living in the property. And sometimes a lease may have it may waive the notice. And so it doesn't, we talked about notice in terms of if the landlord wants to end the tenancy, they must tell you in the last slide within a certain amount of days. But for breach, they don't necessarily have to notify you beforehand. They could just go file. A lot of times in practice, the landlord would send, say, a notice of lease termination due to the breach and list out why it's happening, or they might just communicate to you directly why they're going to file, but they don't necessarily have to, and that's dependent on the lease language. Um, but here, especially if you're a tenant in a subsidized program, you are entitled to notice, and depending on what program you're in, that makes the notice requirements look different, but there is a requirement there. So, kind of why I mentioned it's important to know what's in your lease, what the state law says, and then if you are under a subsidized program, the additional federal or even more state protections that come with that. Okay, and then the last box or reason that a landlord can claim for eviction is a violation of the NC Controlled Substances Act or other criminal activity that threatens the health, safety, or right of peaceful enjoyment. And so this is part of the state statute, state law that allows for an expedited eviction when these violations are present. And so a tenant can be held responsible for the actions of other household members or guests as well. And so it might not be that the tenant themselves did anything, but someone that they had invited on the property or is associated with them in some way could be grounds for the termination of their own tenancy. And a filing like this. At times, the property management, the landlord, or the magistrate might engage in sort of one way to solve this in a partial or conditional eviction, meaning that partial eviction being, say, if there's multiple members of the household, a I'll give an example. Say, grandson lives with the grandmother in the apartment. Grandson did something to violate the criminal activity, something to threaten health, safety, and the right of peaceful enjoyment. Um, they could agree or just to evict, the grandson to go maybe live with a parent or other guardian, and the grandmother being able to continue the lease and to keep the apartment. So that's kind of like if one member of the household or the tenancy kind of splitting it that way, or conditional eviction being that the tenant themselves maybe agrees to, or the judge orders that a certain guest be banned from the property, or other conditions or terms that tend to solve the immediate problem, but also kind of puts conditions on the future as well, in which, say, if that guest comes back with the tenant, could be subject to eviction. And like we saw with the box with breach of lease, the criminal activity also must be described in the complaint. And so the tenant knows what the landlord is claiming, what they think happened, what's going on. So the tenant has notice of that to be able to defend themselves, and speak to what happened in court if they choose to. So, some of the common defenses to eviction. First, there are some state law protections for victims of domestic violence regarding their tenancies. And so, there's kind of a whole section on that. But essentially, if a victim of domestic violence needs to leave their tenancy early for a certain reason, or kind of like the partial eviction that I mentioned, if there's a domestic violence situation between two members of the household, on the same lease, if there needs to be changes to the tenancy regarding that, there are protections there so that people can get themselves out of situations of violence, and that their tenancy can reflect that, and they're not penalized or held in a situation by the landlord or by the lease when that is occurring. Additionally, waiver can be a common defense. And so, also important to read your lease here because there might be an anti-waiver clause in the lease. And so, this is the landlord accepting rent after an alleged violation occurs. And so, say, yeah, the landlord has a problem with a pet. They say no pets are allowed, but you have a pet, but they take rent for, say, 5 months and never, they keep taking rent. Even they're saying you're not supposed to have that dog, you're not supposed to have that dog, they keep taking rent. If there's no anti-waiver clause in the lease, if they eventually try to file for eviction saying, um, you've been violating the lease. Part of what you could argue is that, well, they've waived that because they've been taking my rent the whole time and they've known I have the dog. A lot of the kind of longer form type leases and more corporate leases that we talked about do have that anti-waiver clause, so it's not always a defense, but something to look for. And it's also not a valid defense against eviction based on criminal activity, or failure to pay money that is due. So that's usually, it comes up more in breach of lease as far as the terms or conditions of the lease or behavior on the property, things like that. Invalid notice can also be a defense. And so, especially with the box two holdover that we talked about, if the landlord, say, didn't give enough time, didn't give enough notice, you have a month-to-month lease, the landlord is supposed to give you 7 days notice. They only gave you 4 days notice and then went and filed. That could be a defense to their filing. Or like I said, if you read the lease and it says all notices must be given in writing, and your landlord only orally told you to move out and then went and filed, that could be incorrect and could be a defense to the filing. Additionally, a failure to offer a reasonable accommodation. And so, say there is an issue that's happening between you and your landlord, but part of it is related to a disability, or a need to have accommodation that's reasonable regarding that. So maybe, it's not. Your landlord thinks it's a pet, but it's actually an emotional support animal. You have it documented as far as you need this for your health and for your disability. And so bringing that to the landlord could be a defense, and either in court or kind of settling and mediating around adjusting for that. So there's no longer an issue, or say you need a first floor apartment because of disability, or a certain parking space that's closer to your unit, or maybe something is happening behaviorally with a neighbor, could be reasons to seek a reasonable accommodation related to disability in your health status. Another thing that sometimes happen is that the amount that is claimed is wrong. So the landlord might say that 3 months of rent were owed, but you're claiming that no, it's only, well, not only 2 months, but you might say, no, I paid everything. I don't know where this is coming from. And making sure you have, say, receipts for that, or any kind of documentation regarding what have you paid, and communication with your landlord about it. The landlord also has to demand possession for the unit before filing a lawsuit. And so even though the notice under breach of lease or criminal activity isn't necessarily required, they do have to, make some sort of demand for possession before filing. Um, and then additionally, especially with criminal activity, if the tenant did not know, or have reason to know, and the tenant had done everything reasonably expected under the circumstances to prevent the criminal activity, that could be a defense. And so you're responsible for a lot, almost everything of what your guest or someone that you invite onto the property does, but there is a line to that, and as stated here, it could possibly be a defense. Okay, so that's the filing, that's the paperwork, that's kind of how to understand it. And then we get to the small claims court hearing, where, like I said, most of these start. Small claims court is governed by a magistrate judge, and their ruling is called a judgment. Um, and so usually there's a fairly short hearing. Sometimes they are longer. Um, the landlord, because they have the burden of proving their case, they are the plaintiff in the case. They go first in saying essentially what's on that complaint. Why they have a landlord-tenant relationship, what the terms of it are, what box they checked off, the reasoning for the seeking the eviction, and all of their support for why they think they should get it, right? So say if they filed for that box two holdover, they might produce the letter that they sent to the tenant saying, giving them proper notice to move out, saying that the tenant hasn't moved out. That's their reasoning for seeking the eviction. And then the tenant also gets to go as the defendant and, explain why what the landlord is saying is wrong, or whatever defense might be able to be raised there. Um, and there's also cross-examination allowed. I will say, small claims court, while it still is a court proceeding and is a bit more informal than, say, what we see on TV, or even, what happens in district court. And so just note that usually the actual courtroom itself is a little bit smaller. There's probably only a couple other cases in there, especially in our more rural counties across the state. So totally understand that it's very nerve-wracking. And the magistrate judges, they vary in how they like to govern their courtrooms. Sometimes the magistrate judge tries to work something out between the parties. Sometimes they're just going to hear the case and decide. Um, it also might be helpful, depending on your circumstances, to show up earlier to try to speak to your property manager, the landlord, before the hearing, to see if there's anything that can be possibly worked out, or communicating with them, before the day of the hearing as well. A lot of times we see that things can be mediated between the landlord and tenant, and sometimes the landlords also want to avoid going to court, if they really don't have to. So try to, if it makes sense for your situation, try to see if there's a way to remedy outside of court as well. Um, and so, but small claims court happens, we do have a guide to small claims court on our website as well that can be helpful for thinking through, the plaintiff goes and then the defendant goes and what the judge is doing during that time in more detail. But essentially, usually the judge is making the magistrate is making a decision by the end of that session. Sometimes they decide after and then send out the judgment to the parties, but it's usually decided there on the spot. And both parties have 10 days to appeal. So the landlord wins, tenant has 10 days to appeal the case to district court, and things are kind of frozen during those 10 days, essentially. So the landlord, the day after court can't come and lock you out, can't make you move out, anything during that 10-day period. Or say if the tenant wins the case in small claims, the landlord can appeal for those 10 days during that 10 days. Um, and I'll talk about the appeal process for a second as well in a second. But if a tenant wants to stay in the residence while they're waiting for district court to do the appeal, you still have to pay rent during that time. You just pay it to the courthouse. Instead of to the landlord. Um, and so if the case is appealed by either party, landlord or tenant, the case will be heard in district court and it's de novo, meaning it's new. It's not nothing is taken from small claims. The judge isn't basing anything on what happened in small claims. The parties get to, the landlord gets to put on their case again. You get to put on your case. You can call witnesses. They can call witnesses, produce new documents. It's a new hearing. It's a different judge as well. And so that can be a second chance to argue and a new chance to argue your case despite whatever happened in small claims. Okay, so then we get to the writ and the padlocking process. And so if a tenant does not file the appeal to the eviction, say, during small claims court, the magistrate judge entered the judgment against the tenant, sent, essentially granting the eviction, the tenant doesn't appeal, then that kicks off the process for the padlocking, the locking out. And that's when the landlord can get a writ of possession. So that can happen not only when the tenant doesn't appeal and they have lost in small claims court, but also even if they appealed and it's awaiting a hearing at district court, if during that time the tenant doesn't timely pay the rent bond, so paying the rent within the first 5 days that it's due, usually the first 5 days of the month, the landlord can also initiate this writ of possession process to do the padlocking and remove the tenant. Even if the case is continuing at district court and there will be a hearing, the possession can change hands during that time if the rent's not paid. And so yeah, so after those 10 days, with the appeal not filed or after the rent is not paid timely to the court, the landlord can go to the clerk of court and get a writ of possession to have the locks changed. And so when that happens, they file for it, usually get notified fairly quickly of when it's going to happen. And so you'll get a notice from the sheriff of when the writ will be executed, and the writ is the locking out. And it happens pretty quickly because the sheriff has to execute that writ within 5 days of receiving it. And so what actually happens during that process is the sheriff comes out along with the landlord. The sheriff orders the tenant to leave the premises. Usually you have pretty little time, maybe 5-10 minutes to get things. So it's really important if you get that initial notice of the writ of possession or the notice that there's going to be a lockout, going ahead and collecting things there, especially things that you absolutely need to have with you, because you won't have very much time at the point when the sheriff is coming out. And the sheriff will observe, but the landlord will actually be doing the changing of the locks and or padlocking from the outside to not allow the tenant back in. Obviously, refusal to leave when ordered by the sheriff can have consequences as well, such as trespass. And so knowing what the process is exactly is important, so you can make sure that you're prepared. After the padlocking happens, the tenant does have the opportunity to go back and get belongings within 7 days from the property. Um, this has to be coordinated with the landlord. It's not a kind of anytime I want to, or all 7 days I can go back and get stuff as the tenant. There are some parameters around it, so and it can be hard to enforce if the landlord doesn't allow it. So that's why I said, especially things that you like absolutely need to have with you, such as documents or medication, having those before the lockout even happens is really important if possible. So, during that time could go back. But the tenant only will have 5 days if the tenant's remainings are, things that you've left in the apartment are worth less than $500. So just, it still happens very quickly, but keeping that timeline in mind is important, as well as the opportunities you might have, but also, might not be able to get back in, or get back in for very long. Okay, next we're going to shift to the landlord's duty to make repairs. Um, Very common issue that we see, across the state, and our state law, as well as some additional local law, requires landlords to have a duty, or landlords have a duty to keep their units in a fit and habitable condition for tenants. And so that includes things like obeying the local housing code, if there is one, repairing dangerous conditions in a reasonable amount of time. So a dangerous condition being, that there is not heat when it's December and it's 20 degrees outside. A Landlords must also keep the common areas safe, keep electrical, plumbing, sanitary, heating, and other facilities and appliances in good and working order, and also installing those smoke and carbon dioxide detectors. And so these duties that the landlord has that are outlined within our state law can't be waived or avoided by the landlord. They can't, say, even if it's written in the lease, it can't do that. It can't say, tenant is responsible for making sure the heating works all the time. Things like this that are written into the law, it can't be waived, or written around through the lease terms, even though that happens sometimes, tries to happen. But it's also very, very important to note that tenants must continue to pay rent, unless given permission by the court to withhold rent. And so I absolutely understand how it makes sense as a tenant if something is not working, especially if the place you're renting is in horrible condition, um, to say, well, I'm not going to pay anything in the meantime until stuff is fixed. I know logically that makes sense, but it can legally get you in trouble because it could result in a non-payment of rent claim. And so the tenant must continue to pay rent, and there is a process for um, claiming that you shouldn't have to pay rent with the court. But you can't just unilaterally withhold that rent from your landlord because something is uninhabitable or not being repaired in a timely manner. Okay, and so that process of claiming um, that you shouldn't have to owe the full amount of rent because of these issues that are going on, is called rent abatement. So that's essentially the tenant saying the landlord's failing to do what they're supposed to do under state law, under local code enforcement, and I should be, as the tenant, should be awarded back some of what I paid in rent because of these conditions. Um, and so there's a couple ways to go about doing that, and a couple things you want to consider that you might need. One, if you have a local code enforcement department that offers inspections, that's usually always a good place to start to reach out and see if they would be willing to do that. One, for to gather evidence of the issue, but also some additional enforcement mechanisms there, that could be helpful to get the situation solved. And You'll also want to take pictures. As far as reporting it to the landlord, you must report it in writing to your landlord of something being wrong. And the landlord does get a reasonable amount of time to fix it if it's something that they're responsible for. So, say you report that the heating went out, if they're not able to fix it immediately by the very next morning, that might not be a reasonable amount of time, but say like a week later, there's still you know, no fixing, or the landlord's not even responding, or they're not trying to fix the issue in any way, especially when it's one of those more dangerous conditions, then that will, likely not be seen as acceptable by the court. But the rent abatement is asking for a portion of the rent to be paid back to the tenant because of those conditions. And so, say you go without clean water for 3 months because your landlord is refusing to fix whatever is wrong with the water, and it's not anything by your doing, and you have to say buy bottled water, or you have to you can't use your bathroom, things like that. And part of what for that amount of like how much should I ask for back, or how much should the rent be abated, is or how much should the rent be lowered going forward, is like how much is that unit really worth, kind of like the fair market value of that unit without these things working, or with this issue that's been caused, right? Or say there's a um gosh, say if like the ceiling falls in one of the units of the house, you totally can't use that room. And so maybe that's a fifth of the house that you're not able to use. And so you could calculate it as, I should only have to pay a fifth less of the rent, right? Because I'm not able to use this whole property. That's one way to think of it. And so rent abatement can be done both as a defensive measure. And so, say landlord sues for, a breach of lease, or non-payment of rent, you can bring it up in defense that, that you owe rent because this has happened. But it also can be an affirmative filing, meaning that you as the tenant initiate this filing as the plaintiff, and going to small claims court. And then you have the burden of proving I should be owed back this amount of rent, because of what's been happening. Um, and so in small claims, that also usually starts in small claims court, because the limit is $10,000. If it were to be above that, could be filed in district or superior court, but more than likely going to be in small claims court as well. And there is a filing fee associated with both this affirmative type filing, you initiating the lawsuit, but also with appealing. A case from small claims to district court. But there is a indigency petition, and so if you receive food stamps or other certain government benefits, or aren't financially able to afford the filing fee, there is ways to ask for that fee to be waived, and there is a specific court form for that as well. Um, yeah, so the rent abatement, like I said, can be a defense, but also a counterclaim to a claim for eviction, based on the tenant's failure to pay rent. So sometimes we see that, yes, the tenant may owe rent to the landlord, but what the tenant could claim as abatement, for for the rent, or outweighs what the tenant owes to the landlord. And so it could, it be a counterclaim. There's also potential for debt collection issues around that, depending on the state of the apartment, when and how the landlord is continuing to charge. And I'll also note for all of this as well, if you're in a subsidized unit, usually the housing authority is involved to some degree. Like if you are on a voucher program, perhaps doing their own inspection, perhaps abating their portion of the rent to the landlord. And so there can be a couple additional kind of complexities to the rent abatement process. So here's some more points about the evidence that you can use for rent abatement. The code inspection reports, like I mentioned, the copies of your request for the repairs, because they, like I said, have to be given in writing, and the landlord does get a reasonable amount of time to do the repair before you really have any kind of claim. And so that can be text or emails or work order requests. Um, and making sure that those are in writing. I would take pictures and videos of what's going on. If you can have other people come to be able to witness what's going on and be able to give testimony about the conditions of the home, have knowledge of what those issues are. Um, and to be able to assess the value of like what that apartment or home is really worth given what's happening there versus what the rent price actually is. Um, it's also good practice just as you move into a place as well. Go ahead and take pictures and videos and kind of document everything. Pay attention to, a lot of times the apartment might give you like a sheet where you fill in anything that's wrong so far, so you can know that's not anything that you did to the apartment. Um, Make sure that is detailed and just have the status of the apartment or the unit that you got it well documented. And so if something does happen, or we'll talk about security deposits in a second, it's something that the landlord might try to claim after you move out, you have the evidence, both as something is happening, but also being able to compare it to when you first got the unit, what kind of condition it was in. Okay, so this essentially kind of goes through what I'd mentioned, that the how you measure the damages or what you want to say the landlord owes you for these repairs or habitability issues is what's the difference between, what that rental unit is actually worth, given what's going on, and what it was worth as warranted, through the rent price or through if there were no issues with it. And so thinking about what's the difference between those two. And the tenant can testify to what the tenant's opinion of that is. You don't need an expert or someone to come say that on your behalf. You can testify for yourself what that means. Um, um, and then, yeah, so again, there's a little bit of complication here if you are in a subsidized program, and depending on how much rent you're actually paying, and if someone or a program is paying rent on behalf of you, that gets a little bit more tricky. But then a tenant can also ask for consequential damages. So kind of like what I mentioned with the water example, say you had to go and buy other things, or especially with the heat example, if with all the snow and ice we've had lately, if it's just absolutely untenable to stay in your unit and the heating was out, if you had to pay to stay in a hotel or do something else to navigate the situation, if the landlord wasn't responding to the request for repairs or wasn't adequately filling those requests to make the unit habitable again. And so you want to make sure you're keeping track of all of that as well as part of your evidence. So, receipts, pictures, videos, all of that. Okay, sometimes we get questions about the tenant breaking the lease. And so the tenant is bound to the terms of the lease. It's part of the contract you enter with the landlord in establishing that relationship. And this includes any terms to leave the lease early, try to terminate the lease early. Um, and generally, the landlord doesn't have to allow the tenant to agree to break the lease early, or sometimes there's like a buyout clause or fee involved with leaving a lease early, that's included in the lease itself. But I will note here that domestic violence exception. And so if a tenant is a victim of domestic violence, they may be able to break the lease early. And in those situations, the tenant is required to provide the landlord with the specific documentation and a 30-day notice regarding the domestic violence situation that's going on, perhaps a protective order that's been granted or an ex parte order. But the tenant is still responsible for the rent during those those 30 days. Um, and which is also important to note when we were talking about notice and the tenancy ending. Even if the landlord says, they say now, I'm ending your tenancy at the end of March, rent is still owed throughout that time. Or you tell your landlord, maybe you're on a month-to-month lease and you only want to stay there through April. You still have to pay rent, up until that time that you move out. Um, and so a tenant can be held responsible for the rent through the end of the lease term. But the landlord does have a duty to mitigate those damages. So trying to find a new tenant to take the tenant's place. Say you signed a year-long lease but need to move out after 2 months. And making sure you're checking your lease for the specific language around that as well, and what the ramifications of that are. But it is a binding contract for the whole term, and so making sure that you're including that as part of decision whether to move or not, and what that might mean to try to break the lease. You could be responsible for the rest of the rent owed under it, especially if the landlord does try to mitigate the damages, does try to find a new tenant, but there is not a new tenant to be found. Could run into some issues there. Okay. Um, Last thing we're going to touch on are security deposits. I know we're getting close to that. I know we have longer than an hour, but getting close to the hour part of this presentation. So security deposits is another common question. And there's some state law around it. And so after you move out, the landlord has 30 days to return the security deposit or to provide the tenant with an itemized list of deductions. So normal wear and tear cannot be deducted, and a landlord can potentially have 60 days to return it, but within that first 30 days, they have to send that initial accounting. And so maybe it's during the initial accounting, say like it's an estimate of how much it is going to be to say something happened, you broke a banister off of a stairwell. They have to estimate how much that is going to be to fix. Um, and they're going to deduct that from your security deposit. Um, so, but it's important to note that because the as a tenant, you can't go to court and try to claim any of that money back until this process has run out, right? But a lot of times we might see the landlord hasn't said anything at all. It's been 30 days, it's been 60 days. Maybe they're not responding to messages. No money has been returned. And so the tenant then can ask for that money to be returned in small claims court. Um, and so the that that is called a request for money owed, and the law around security deposits being the basis for that. But essentially, you're asking the court for the landlord to return that security deposit. You also want to, again, we're talking about documentation of and evidence that you might want to have the pictures, the videos of when you moved out, how everything looked, having that for when you moved in as well. If you wanted to bring any additional people that could testify to the condition of the residence as you move out, documenting when you handed in the keys, having as much in writing as possible is always helpful, in case, say, something happened after you had totally vacated the unit, turned in the keys, you're not in possession of it anymore. Um, yeah, and so you can sue for that, and the magistrate could enter a judgment for you and against the landlord, ordering them to return that money to you. Alrighty, so I know that was a lot of information. We have open time for questions as well. But I also just want to point out if If you are currently facing an eviction issue, you can always call our helpline or apply online for our services to see if you can get advice or brief or representation in your case. Our helpline number is there as well as our website. There's also a lot more resources on our website, such as the Eviction Defense Manual and the Guide to Small Claims, and more information about security deposits if you want to read more about kind of anything that we've discussed here. Additionally, we have a senior legal helpline as well with the number and because unfortunately we can't take every case that we would like to with limited resources, another option is to find a private attorney through the North Carolina Lawyer Referral Service. They do offer a lower rate, a low bono rate for initial consultations and in those 30-minute conversations. So that could be an option that is provided and ran by the North Carolina Bar Association, not legal aid. And so our services are free for those who qualify, but realizing that not everyone can qualify for our services. So there are other options out there as well.
Awesome. And so if you have a question, you either need to type it into the Q&A box if you're on Zoom or put it in the comments section on Facebook. Not seeing any questions at the moment, but I did just want to pinpoint. Megan mentioned that you can apply online. I've actually put a link, and let me put it again because I had just mentioned it for subsidized or income-based housing. There's now a link in the chat to our new Justice Hub, which is going to be a much easier way to apply. Skip the phone lines, don't wait on the phone, go ahead and see. It's a great way to find out if you even qualify before going through the application process. So I encourage if anyone's interested in seeing if they qualify for services from legal aid to click that link to our Justice Hub. And then same thing as I also put in the chat, if you live in subsidized or income-based housing and you are facing an eviction, I heavily encourage you to apply for legal aid as soon as possible to see if we might be able to provide advice and or representation. Um, Not seeing any questions, so I am just going to leave it for just a minute here to see if a question does come in. You cannot unmute in this forum, so if you have a question, you either need to type it in that Q&A box on Zoom or put it in the comments section on Facebook. Again, going to leave just a few moments here to see if any questions do come in. All right. As I am not seeing any questions, I'm going to go ahead and say thank you to all of you for joining us with a very special thank you to Megan for presenting for us. If you would like to review anything that Megan talked about today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access the recording with or without a Facebook account at www.facebook.com/legalaidnc. The recording will be available for about 30 days and then it'll be available to review at any time on Legal Aid of North Carolina's YouTube page. If you would like to register for one of our other Listen and Learn programs that Megan mentioned at the beginning of her presentation, such as child custody, SNAP benefits, wills and powers of attorneys, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so very much, and I hope everyone has a wonderful rest of their afternoon.